Hello, everyone, and welcome to 6 Ways Your Managers Are Causing FMLA and ADA Lawsuits and How to Train Them to Stop. Thanks to the 3,000 plus people joining us today. We are humbled by your interest in this program. So thanks for joining us today. This is us, your jolly webinar host, the Cheech and Chong of FMLA, if you will. I'm Jeff Novak. I'm a labor and employment attorney at Franczek, a labor and employment boutique firm in Chicago. And I'm joined today by Matt Morris, the Vice President at FMLA Source, a leading third-party administrator in all things FMLA and other leaves of absence. Many of you do not know this, but it's Matt's long-held tradition to wear this elf hat the entire month of December.
Whole month.
Your brim is getting a little crusty there, my friend. But
it's
okay. There's a half month left to go. We're also terrible, awful businessmen, because in the next hour we're going to unveil and provide the contents for your very own FMLA training program for your managers. And instead of selling this to you for something like $19.95, we're giving this to you for free. Matt, we've done some dumb things together, but this may be the most foolish. As a result of this ridiculous effort, these folks are never going to hire us, and our families may not eat for weeks or perhaps even months.
Yes.
But in all seriousness, we're excited to share our thoughts with you, all with the goal of improving your FMLA compliance. Before we jump into our presentation, just a quick few housekeeping items to mention. At the end of this webinar today, there will be a pop-up on your screen with a link to a survey. Please fill that out for us. We need you to fill that survey out for us if you're seeking HR, CI credit, or SHRM credit, or CLE credit. So please fill out that survey. If you have any questions that you want to pose to us during the webinar, you can use the chat feature toward the bottom of your screen. So feel free to use those for questions. You can also tweet any questions to us at #FMLA webinar. You're probably not hearing this if you are having audio issues, but if you are, please email my colleague Morgan at the email here on this slide to obtain an audio number. So let's start with a story. This is Jake. He's one of your managers. He manages Debbie. Jake wants to fire Debbie because she took FMLA leave. How do we know? He wrote it down. In Jake's email to HR, he stated, "We need to move to termination as soon as possible for several reasons, including that Debbie submitted a request for medical leave." One day, Debbie sued. And in that lawsuit, Jake is deposed. And he told us why he did what he did. He said, "I'm not really familiar with the FMLA because I'm on the front line."
Great answer, Jake. So we put that in there for you to do the screaming. This is the point of the presentation today. This is not the story of Jake is not an isolated event. This is becoming more and more common. Your managers are killing you. And yes, even the fact that your HR function is stretched thin, this isn't a good excuse. In fact, it's worse. We put this case on here, Abdel Massa. This HR person, so if you think you have a tough job, had 3,600 employees for 5 northeastern states and D.C., and the HR person herself was in Dallas. And in this case, because of that lack of being able to help her employees, you had a plaintiff who worked in one of the stores who was told he should always wear his dentures because he looked old. When he needed FMLA for his COPD, no one told him about the FMLA. The guy's son had to tell him. And when he filed paperwork, this is my favorite part. This is not going to be the last time I mention this today. The manager accepted the forms to his small credit, and then left them in his car for literally years. And HR never even saw them until the case was in litigation. In allowing this case to proceed for Mr. Abdelmassa, the court said, recognizing the problem with this process, that the employer can interfere with an employee's rights by rendering him unable to exercise that in a meaningful way. And as troubling as some of these cases sound for you today, take solace in this. At least you're not at the organization where the manager leaves the certification in his car for 3 years. And how do we know this is more and more common? We'll take a look at this quote from DOL Branch Chief Helen Applewhite from the DOL. This is from earlier this year. Frontline managers who are often unaware of what is protected by the FMLA or uninformed by the role in the process. We're going to dive particularly into this. They also sometimes engage in improper communication with employees about motives or personal lives, and it's exactly these types of behaviors that can lead to discrimination or wrongful termination and liability. And this is reflected in the courts. What we're seeing is a marked increase in managers creating issues. That's why Jeff and I thought this was important to talk to you about, particularly in liability in places where there are sound policies and where we otherwise shouldn't see issues. And why is this happening? Well, we're not sure, but it could be that comprehensive leave training hasn't happened since the regulation overhaul about 9 years ago. It could be a different marketplace with different workers of a different generation in remote places like the case we just talked about, or it could be a lack of training. And so we're going to talk about that a bit. And according to the surveys, the manager-employee relationship isn't helping things either. Our own survey at my parent company, ComPsych, which was released on Monday, showed 57% of employees feel isolated at work, and that's the good news. Monster's survey, which is what we show you on this screen, and as you see, showed that employees hate their managers. They find 76% say they have a toxic boss, 25% say a power-hungry boss, 17% say they're incompetent, and so on. And by the way, the number of incompetent managers we're going to talk about in the next hour is probably more around 98%. So let's go to the agenda.
With that, we're going to cover 6 critical topics that you need to build into your FMLA training program. And for each of these 6, we're going to provide some recent cases, not to bore you with case law, but rather to provide fact patterns that you in turn can share with your managers as education for them as to how they might respond to a situation to help them issue spot. We'll provide examples of what managers should do, and along those same lines, training tips on what they need to know when they're receiving that request for FMLA, when they see a pattern of suspected misuse. What tips can you provide them so that they are in the know, that they know their responsibilities as managers?
Okay, so here are our offenders, and what we mean by that is of the dozens and dozens of cases we've seen, particularly again over the past few years where managers screw up, they really fit the type of one of these 6 geniuses on the screen. So they are the space case, and the space case is the guy who, when presented with a medical condition, should have detected it as FMLA or ADA, but is too spacey to recognize it. Offender type 2, that's lazy bones. And unlike space case, he knows there's a leave at play. Good job, lazy bones. But the employer never fulfills its responsibilities because lazy bones never makes sure it's addressed. Our third guy is the head stuck in the book guy. This guy sees intermittent abuse. We all know about intermittent FMLA abuse all around him, but he either doesn't know it or he doesn't do anything about it. And as I'm sure you know, these are often the guys who blame you about it. Our fourth offender, the overshare. This is the manager who is constantly saying the wrong things. Sometimes she blurts it out at the leave request, sometimes on a performance review, sometimes she comments on the inconvenience of it. Whatever the case, it's never good. 5, the badgerer, the sinister badgerer who is constantly bothering people when they're out on leave. That's rarely a good idea. And then lastly, our troublemaker, the manager whose participation in the employment decisions for the employee ruins the case. So those are our 6, and let's start with the space case.
Great, thanks, Matt. So the space case focuses in on recognizing a request for FMLA leave. You'll spend a lot of your training time with your managers teaching them about recognizing what is and what is potentially not FMLA. It's really important. These are the people on the front lines, right? So you don't want a space case. You want someone that can recognize a request that potentially falls in the FMLA bucket and then know what to do with that request. So what I typically do in training managers is I start out with a couple of examples. This might be an example here, and of course these are court cases, but I provide them the cases to the attendees in a kind of a fact format that you see here, and I might use them as examples. I might ask the attendees, the managers, to issue spot. What are the potential problems here? Why did the court find this way against the employer? So take Michaela, for instance. She's a registered nurse. Charge nurses in her area were aware that she had migraine headaches and that she was on medication for them. She had frequent call-offs. Some of them, she would let them know, I'm dealing with a migraine headache. For others, she might just reference headache. There were vague attendance logs as well that were maintained by the supervisors noting headache, in quotes here, and nothing more as the reason for the absence. And here the court said, employer, you're in hot water. You should have recognized these call-ins as possible FMLA situations when an employee with migraine headaches calls in and references a headache that your manager may need to probe further. So what I would do in a training session is ask the managers to issue spot here. Why might the court have found this way? And asking your managers to identify the vagueness in the kinds of headaches that were going on here. Similarly with our Sean example. Again, and this is just a coincidence that we're dealing with another nurse, but here we're dealing with an RN suffering from a congenital heart condition. She leaves work early to go to the ER due to an irregular heartbeat. Then she misses a number of shifts, calls in sick. She misses a couple of others, and in fact, I think in this situation, she even asked employees to cover a couple of shifts for her. She returns after what is a leave of absence of about 10 days with a doctor's note indicating that her absence is due to a heart condition. She is promptly terminated for violating the attendance policy. And here the court said that the employer had enough information about a health condition that may fall under the FMLA that it should have inquired further about whether FMLA may have covered any of these absences. So again, to your managers, help them issue spot or challenge them to issue spot. You know, what are the problems here? Where did this case fall off the rails? And get their buy-in, get their feedback so that they can start issue spotting themselves. And I use these examples to lead into an education about FMLA. We don't need to spend oodles of time going through the boring, lengthy definition of a serious health condition. But it's really important for your managers to know, generally speaking, what kind of absences fall outside of FMLA and are covered by your sick leave policy, and what absences could be FMLA. So in the session, I walk them through these 5 bullet points that you could have a condition, could be a physical, a mental health condition, an illness, injury, physical or mental condition as the definition of the reg state. So it literally could be anything, any kind of condition that includes one of these 5 categories. And so I go through and spend a few minutes explaining to them what each category is. My focus in this area is on what you see in italics and in orange, because those are your most common 2 situations that your managers are going to deal with. One is in bullet point 2, one is a lengthy leave of absence, more than 3 consecutive days. They don't need to be work days, they're calendar days, more than 3 consecutive calendar days. and some kind of continuing treatment. We don't need to define what continuing treatment means for the manager. You might stop simply as saying, look, we typically need a doctor's visit with some kind of medication or treatment involved, or we need a couple of office visits to the doctor. That's what continuing treatment means, so that they have a general idea of what this leave looks like. And then secondly, I'll focus on bullet point number 4, the chronic serious health condition. And the key there is to get across the point to your managers that these are kind of the bane of your existence, right? These are the chronic, episodic conditions that flare up from time to time that you as managers are going to have to deal with. So the focus there is an emphasis on that these are going to be occasional absences. They're going to be episodic. What does that mean? They're going to be occasional and at irregular intervals. They're going to pop up from time to time. They're likely going to be a lifetime event. Migraine headaches, bad back, for example, are typically lifetime conditions. So help your managers understand the basic definition of FMLA, so again, they have some idea of what is and what is not a serious health condition, because they're going to in turn need to do something with that information, right? Either they're going to have to act on it themselves if you're a smaller organization and your managers are heavily involved in your FMLA process, or they're going to have to pass that information off to HR or a leave administrator or maybe even a TPA. So I might use in training these tables here in this slide to spend a few minutes again what is typically outside of FMLA and what typically is inside and covered by FMLA. Now that they're experts in the FMLA, I transition typically to this kind of hypothetical. I talk about Fred and his bad back. He calls into his manager before his shift to report off work. He reports that he's been dealing with a bad back and he won't be in today. The next day he calls off sick again and he references the same condition. Same thing as yesterday, he tells you. And he reports to work on the 3rd day. And so I pose the question to managers, and I think you should too, is this 2-day absence covered by FMLA? And what we want them to do is to recognize that this may or may not fall into the FMLA. For a moment, for a fleeting moment, we want them to be like attorneys. Not too attorney-like, right, Matt? Because we don't want that. But we want them to answer the question by saying, well, it depends. That means that they're understanding some of the content that you've been providing. Because it could be an episode where they fell off their ladder over the weekend. They don't have a bad back. They don't have a chronic bad back. It's a one-time event, and so it may or may not be FMLA. Maybe it's a lifetime condition, something they've been dealing with for a long time. That's a chronic condition. That may be covered by FMLA. So here is where you have to make a decision as a company, as an organization. How involved are your managers going to be in this initial process, in that phone call where Fred calls in about his bad back? The regs, and this is the part of the training where you can kind of disavow the notion that we need to stay away from medical information. There's a misconception among employers that we can't ask about medical conditions. We can't. That's covered by HIPAA, and so HIPAA is raised either by the employee or maybe even the manager. They are your employee. You have the right to know why they can't be at work, and so you have the right to ask them some questions about why they can't be at work. And here, if your managers are going to be involved in that process, and look at your FMLA policy right now, are managers part of that FMLA process? Even though you may not think so, many of your policies say that they are. So if they're involved in that FMLA process, that leave management process, arm them with some questions that they can ask. What's the reason for your absence? What happened? So when Fred calls in and says, I got a bad back, well, Fred, what happened? It could be something as simple as that, to get at some facts as to why he has a bad back. Ask questions about treatment. Are you going to get treatment? Are you going to see a doc for that? Have you previously taken leave for this absence? Get a sense of start and stop times. When do they expect to return to work? Here, I might have a script ready for my managers of the kinds of questions that they should ask. Again, only if you are including them in the FMLA process. That's really important. And here's one of those critical junctures. Well, I'm going to make sure that you're listening to me. If you want a script that I prepare for my clients, send me an email and ask me for that script. I will send it to you after our session today. It's a script of questions that either your manager or leave administrator can ask someone in Fred's situation when they call in for an absence. But Matt, let me turn to you at this point. This decision that employers have to make as to how involved managers are. What about the flip side where managers aren't involved?
Right. So before we train all our managers on what to say, that to Jeff's point, we should think about how and do we want them involved. Coming from the TPA world at FMLA Source, I just say if you have a TPA or otherwise you've centralized your operations, you may want to consider limiting that amount that the manager does, having the manager get the initial information and then take that hot potato and send it over to the TPA, to the in-house centralized operations, and let them handle it. Let them do those investigative questions like Jeff said. If you don't have that, then to Jeff's point, you're going to want to make sure you get that and you can have the manager do it. But you see the script right here. Let the employee, tell the employee where they should go. Explain there's no further need to discuss it. Obviously, if we had our druthers, we'd want to keep the manager out of this as much as possible because it is to some degree creating risk if they don't know what they're doing. So you can have the manager say, no further need to discuss it, put fingers in her ears and start yelling, la, 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 that's fine with us. And then saying to that employee, we're not going to follow up with this with you. This is important in terms of the expectations, especially as we get into the next character that we're discussing, the lazy bones type. And although you would also benefit from having your supervisors follow up with a provider or center to make sure they're on the lookout to some degree for some documentation of receipt to make sure that they have it.
A couple of specific situations that you may want to deal with, again, all in terms of helping them recognize a possible FMLA request. Clients often ask me to address in a training session, well, what about that employee that walks off the job? They show up for work, and then they see how much work they have to do that day, how many widgets they have to create, or how many pallets they have to move, and suddenly they're sick, they need to go home.
Yep.
So again, same kind of script here, but I think the manager, if you want the manager to be involved, that we can ask some more directed questions here. So train them on, again, what's the reason for leave? What's going on? When did the condition begin? You came here to work, and now the condition has flared up. Help me understand that. What brought it on? You may even have managers, you may even be comfortable, and I'm comfortable with this if managers are properly trained, to even go further and say, look, John, you showed up to work today. You weren't dealing with this issue. You found out how many pallets you needed to move, and now you need to go home. Help me understand what's going on here. That, to me, is not interference with FMLA. You're asking the question of the employee and frankly, holding their feet to the fire as to why they need to leave. Consider accommodations short of sending them home. Do you need a break? Do you need to sit down for 15 minutes rather than leave? No harm in arming your managers with that. But make sure that your managers know what is the protocol. Do they need to send them to HR before they leave? Make sure that in that training you're directing them as to how to handle that situation if someone else at the workplace needs to see them. Situations involving doctor's appointments, the last-minute doctor's appointment. Hey, I'm going to the doctor tomorrow. I'm sorry that I didn't tell you sooner. Well, this is kind of the low-hanging fruit of the FMLA. Push back in these situations. Of course, if we're dealing with an emergency situation, that's one thing. But we can expect that our employees generally are going to provide significant advance notice to us about the need for a medical appointment. So make sure that that expectation is set out up front at the approval stage when FMLA has been approved, that there is a sit down with the employee. These are the expectations as to when you're going to have doctor's appointments, when you're going to let us know. And what about a tardy response? Managers certainly can ask, well, what are the office hours? Can it be scheduled around the workday? Is there a way that you can schedule it around our operations? Again, the FMLA allows us to do that, and certainly here in these situations, perfectly acceptable. But the bottom line for managers, make sure that they are aware that the FMLA process itself is triggered by the employee, but they don't have to divine when an employee needs medical leave. But also warn them that they don't need to use the letters FMLA, that they simply have to provide facts that indicate that this may fall under the FMLA. So they, it's important for them to recognize the signs of a serious health condition, those 5 bullet points we talked about several slides earlier, and to focus in on comments that employees make when they call in sick, call in that absence, that they're focusing on the words that the employee is actually using. Quickly, in terms of the ADA, same concept. When an employee is asking for an accommodation, again, our manager's role in the ADA process is almost always simply one of being able to recognize when an employee needs assistance in the workplace. So I'll use a couple of slides in training session like the kind here where I explain to managers what a request for an accommodation actually is. It's a change at the workplace connected to some medical impairment. That's what they're looking for in this request. And it can be behavioral changes that the manager is witnessing. But similar to FMLA, they need to key in on words and the content of the conversation with the employee. I list here a number of triggers in the ADA process. You may want to share this with your managers as well, that a request for an accommodation can come in many forms, many different forms. And I might use this slide as a hypothetical for managers and helping them identify a request for an accommodation under the ADA. And you're having that conversation with an employee about their poor performance, and they make some it might be a flippant comment or an excuse that they make, that they tie their poor performance into, in this instance, a mental health condition. I have depression. I can't concentrate with all these distractions. First of all, make sure that your managers recognize that this is a request for an accommodation, that they're looking for assistance in the workplace. Does the manager have to provide one? Are they the decision maker here? No, that typically is handled by someone else in your organization. But you want to arm them with some questions that they can ask the employee in that conversation so they're not caught flat-footed. So at a minimum, I want my employers to ask the question, well, and of course, this is after the performance discussion. So you've already had the performance discussion. You don't let that go. You're still properly disciplining the employee, but then you turn to their request here for what is assistance in their job. Ask them the question, is there anything we can do to support you in performing your job duties, in meeting our expectations? You're not mentioning ADA, you're not mentioning disability or medical condition. You show that you're supporting the employee. It opens the door to the interactive process, and it's an overall good management practice that they're going to be using. And then, of course, they're going to take that information to HR or to the appropriate person, letting them know, hey, I had this conversation with my employee. What are the next steps involved here? So that's the space case. Moving on now to lazy bones.
So lazy bones, again, this is the manager who knows of the policy, who's may have done all of the right things that Jeff just mentioned, and yet that's where it stops. So the employee or the manager doesn't take it that next step further. So our first case, we have Eugene. The company policy at Eugene's company says the employees must call in all absences to a particular number. They had a dedicated number to a centralized department. And sometimes Eugene, who has an FMLA leave, will call that number for his back pain. And then sometimes he'll just instead text his manager. So you can already see where this is going. Eugene has an absence. He texts his manager. What happens now? The employer fires him and says, this is an unexcused absence. You didn't report your leave. Eugene says, yeah, but I did. I do what I always do. I just, I texted my manager. The employer says, yeah, but that's not the policy. How are we supposed to know? And in this case, the employer said, or the court said, that the employer may have that policy, but if you erode it through different practices, then the policy isn't being enforced. And here the supervisor set a pattern and found that other modes of communication would be deemed acceptable because of the manager's behavior. Similarly, we have Terrence. So Terrence has sickle cell anemia and diabetes. He tells his manager, the superintendent, Dr. Clancy, he says, I need to take leave from my sickle cell anemia. Clancy takes this one step further than what happened in Eugene's case. Clancy says, that's fine, I got you covered. Here's the name of the person to speak to, just call them. Terrence goes to the person, but he and his wife keep telling Clancy of the absences. And here's the question. Is Clancy's employer then on notice of the FMLA request because Dr. Clancy herself knew, or was the employer responsible, or was the employer not responsible because Terrence didn't call the main number? And of course, this is something that we could see going either way, but in this case, the court said yes, because of Clancy's behavior continuing to take those requests for leave from Terrence and his wife, that this constituted a violation of the FMLA. So employers can't hide behind these policies. Yes, the employer is on notice. Clancy knew in that case, and while employers often are allowed to enforce their business rules and the regulations, I think that the takeaway here is if you continue to allow this well-beaten path of practices that override your policy, it doesn't work. And finally, you have this Bodie case. In this case, the employee had a mental health condition, and according to the case, it was so severe that she couldn't even call in. In fact, she was hospitalized. And the employer knew this. They seemed to know that she had this condition, but they kept saying, well, she needs to call in herself. In this case, the employee's adult son called in. So clearly, Bodie and her family were trying to let the employer know. The employer kept saying, nope, you can't call for your mom. She has to call herself. So here's a shocker. The employer lost, and not only that, it was compounded by liquidated damages, all told about $284,000. So two things with this case. One, the son can't call for his mom thing, that's just wrong. Probably many of you know that, but for those that don't, the FMLA regs specifically say that notice can be given by a spokesperson for the employee, and the regs name some examples of that: spouse, adult family member, other responsible party, if the employee is unable to do so. And in this case, the Bodie one, you could see this employee is hospitalized for a mental health condition. Obviously, she's probably not going to be able to do that. And then two, the employer can't just pretend that it didn't know what was going on and then, like a lazy bones, refuse to get the information to the proper authority. So in all of these cases, Bodie, Hudson, Preddy, which was the Clancy one, as we put those together, we're making that link between the manager or the supervisor who now knows and making sure that the process then starts. So how do we train our lazy bones? Well, first, make sure that if you have particular proper channels, and again, as I said, you can have that, You can enforce business rules. If you have that process to make sure you train your managers to let them know they have to enforce that. They need to constantly push the employees away and say, you need to call this number or you need to email here or it won't count. They can even make you as HR the bad guy. Who cares as long as they do it? Saying, look, I'd love to take this by text, but the company policy is you have to call this number. And then secondly, you want to consider having the supervisor be the fail-safe. If the employee doesn't in fact go, like in the Terrence case, then the manager, the supervisor needs to shepherd that back over to the party that's doing the leave administration. Again, whether it's a centralized operation or a third party. From our perspective, as a third-party administrator, we're sending that supervisor a notice at that point to say, hey, we've got it now. And all you need to do if you have that sort of provision or that operative piece is just let that manager or supervisor know, train them to say, look, that hot potato is still in your hands until you get that email or notification that says that the centralized operation or third-party administrator has got it. So then what do you do? Again, that's the TPA or centralized example. Centralized operations example. What do you do if the supervisor is involved in the leave? Well, as Jeff said during the space case, you got to script this. The manager needs to know what to say, what not to say, and again, he shouldn't leave the leave papers in his car for 3 years. So the final point on this to close, it's very important not only to make sure that the supervisor has heard everything and not cut off the conversation. You see in italics there at the bottom. Is there anything else you'd want us to know? This is critical. Again, so not only is this not a situation where the employee thinks they've told you everything, but maybe hasn't, and then you get in, if this goes to litigation, you're constantly dealing with what was said and what it wasn't. But this is also critical for the ADA, especially as the employee may be asking for an accommodation in lieu of or in addition to the leave, and you want to make sure you understand what she's told you, again, not just what she thought she told you. Okay. That's lazy bones. Onward to type 3.
The head stuck in the book. So let's assume that in many of these cases FMLA has been approved, and now you want your managers to be on guard and help you identify FMLA misuse situations. And in this part of the training session, I start out with a hypothetical because I want feedback from my managers. Such an important part of this training, keep in mind, is that it's interactive. You want your managers to participate. And so this scenario is one to get them talking. So Fred is one of your direct reports. He suffers from IBS. You know that he is going to be absent 2 days a month, 1 day each for his medical condition. And you all work at workplaces that will have different approaches to how much medical information you provide your managers. Maybe the manager only knows that Fred has a medical condition of some sort that he's dealing with, and he's going to be absent 2 times per month, 1 day each. For the past 3 months, here's Fred's pattern. Over the last 3 months, he's been absent 1 month 3 times, the next month 2 times, the most recent month 4 times. His absences almost always fall on Mondays or Fridays. He recently requested a vacation day that was denied, but then called off FMLA on that very same day. Is there any problem here? And I want the managers to talk to me about this. What do they identify as a problem with this scenario? And I want them to, at a minimum, to be able to recognize the increased frequency of absences over the past 3 months, that they're all falling on Fridays and Mondays, perhaps an extension of the regular weekend. And I want them to recognize, third, that there's something suspicious about an employee who requests a vacation day, is denied that vacation day for perfectly legitimate reasons under your operations, and then lo and behold calls off FMLA or sick on that very day. we want our managers to recognize that these are potential problems. They may not act on them, but we want them to recognize them so that we in turn can train them to do this in response, whether it's to go to HR or a leave administrator, that they're the eyes and ears of our operations. And in a way, we are deputizing them in this process, that they are our eyes and ears in this process to root out FMLA abuse. And Matt, let me turn to you really quick. Why is that so important?
Yeah, I think it's important for two reasons. One, like you mentioned, the manager is the only role that can do that. And I have dealt with dozens of employers through the years where the managers just don't see that. They get it once they're told, but if you're the manager and you're told, well, this is being centralized, or HR does this, or a third-party administrator does this, sometimes the wires don't connect and the manager thinks, oh, well, you know, they'll be able to root out all of this potential intermittent FMLA abuse. They don't realize that they're the ones that need to be the ones seeing this. And so there's no better way, in fact, most of the time there's no way to get that information other than going to the manager. Now, the other part of this is that, and you, for those of you who are in HR, you've probably heard this before, you get complaints from managers who say things like, why aren't you taking care of this? Or why isn't the centralized operation or the third-party administrator taking care of this? Why, I've told you several times that, or I'm having a lot of problems with Judy and Randy who are taking these leaves. Well, if you deputize them with that responsibility to give you that information, it gives them a role in the process so they feel like it's happening, and that you're not, you know, kind of waving a wand to root out abuse. They understand practically that they're helping solve this by what they've presented to you.
So investment in that process is really important. In your discussion with managers, help them to key in on all these bullet points here. Excessive absences, increased frequency of absences. Now, you may know that in HR. You may know that in payroll. You may be able to see that pattern when you're paying your employees. And HR may already be on the game on this one, but you also want your managers to be invested to recognize those as well and report them to you, to have a conversation with you, because they're also going to be helpful to you in explaining, well, Fred was absent on this occasion because of this. He was absent on that occasion for this reason. It helps you together identify how you're going to attack this increased frequency. Friday, Monday, of course, that goes without saying. They should not be completely out of whack with those absences from Tuesday to Thursday. So you want your managers to recognize that. Same thing with a denied vacation day. We see similar issues with extended holidays. So the employee who will take the day off after 4th of July or the day off after Christmas or Thanksgiving, that's potentially suspicious. So you want your managers to recognize that and engage you, HR, or in leave in a conversation. But in your training program, direct them on where to go. When they see these patterns, where do they go with them? Similarly, when they receive information from their subordinates, from their employees about potential misuse of FMLA. So how do they respond in this situation? Use this as yet another hypothetical for your training and get them to respond to you. And then you can in turn explain to them how you as a company or organization are going to approach this situation. So you have an employee that is working another job or is playing a recreational activity that's inconsistent with his or her need for FMLA leave. They're absent, of course, from your workplace while they're doing these other things. A coworker informs you about the situation, upset that they have to carry the load while the employee is on leave. Toss this out to your managers. How do they respond to this situation? Use it as a teaching point. Maybe you want to role play this situation as to how they're going to react. Ultimately, you want to teach them on how to respond to the comment from the coworker, but then you also want to train them as to what do they do with this information. In almost all situations, you're going to want them to report that information to HR. But explain to your managers in this training session what you're going to do with that information and how it's so important that they provide you with this information, because you in turn in HR are going to gather the facts from the employee reporting the behavior. Maybe you're going to include the manager in that process. Particularly if you're a smaller employer, the manager may be involved in some fact gathering, but help them understand their role in the process and what you're going to do. You're going to gather the facts. You're going to interview employees that have knowledge of those facts. You're going to discuss it directly with the employee. And you briefly explain to your managers that there are some options for us that are perfectly lawful that help us weed out FMLA abuse. And their role in this process is so critical. So that's the third type of manager that we need to train in our training. Moving on to number 4.
Oh, yes. We are at the overshare. Here we go. Again, this is the person that can't keep his or her mouth shut. So you have a great policy, and maybe you've trained your people, and most of your managers are great, and they're doing exactly what you trained them to do. But then you have the overshare who goes ahead and says something, and we're not going to go through all of these because there are a billion cases. Jeff and I have counted them all. There's a billion. And this just shows you what Branch Chief Applewaite's point was about improper communication, as she put it, and what a growing problem this is. But we want to walk you through 3 different kinds of flavors, or a few different kinds of flavors of this. So here's the first one. This is the reactive manager. So your manager gets an FMLA or ADA request, and in response, he or she doesn't say, "Oh, okay, we're sorry to hear that. How can we help you about that? Help you with that? We're concerned about your well-being," the kinds of things we're talking about, scripting it out. And instead, the manager says, really, any one of the 4 things for any one of these 4 cases in the last 2 years that you see on your screen. They say, well, you've missed a lot of work, or that's too many days off. The courts look at these cases as belying a hostility towards the leave that is then part of the case, or the employee wins, as they did in these cases, as an interference or retaliation case. And there are more cases, as I said, than what's just on here. In recent weeks, we've had one where here in the 7th Circuit where somebody called the employee, quote, "a constant pain in my butt," and one from the East Coast where the employee says, "I need to take leave for depression," and the manager just says, "suck it up." And then we have perhaps the pinnacle of these cases, or at least one of the 3 that are the nominees for Best Comment of the Year, the Drew case. So this is a couple years old. Drew is a stellar employee. She's been there 15 years, and she tells them she needs to take a leave of absence to undergo a hysterectomy. And in response, her supervisor allegedly said, it's not a good time to take a leave, and then urged her to read the book titled No More Hysterectomies. Now, Jeff and I are imagining we should give you a couple minutes to finish gasping. Guess who won this case? This is a challenge. They later add insult to injury by saying that, well, if you're terminated through this RIP, that really is more of a blessing in disguise because you weren't going to be able to give 100% to your job anyway. Again, lots of training needed here. I would say another nominee for case of the year is this manager from Jersey Mike's. Now, the screenshot is actual text from the manager who told her, as you can see on your screen, this isn't going to work out because she's leaving for maternity leave, and after all, the employee should have told her that in the interview. Great point, manager. The employee then posted this on Facebook. Jeff saw it and put it on his blog, and the employee is apparently suing now. Jeff and I are also taking wagers as to who's going to win this case. So those are fun. And then we have this set of cases. Now, of course, none of you thinking, got it, the manager should not make comments directly to the employee. All other jerky comments are totally fine. But in case you were, there's this raft of cases. These include comments like in the Diamond case at the top, where the manager blames the quality of the work on the employee's FMLA absences. And I find these are a far kinder way to lose the case for the employer, because it allows that employee such a much more convenient, I'm being sarcastic, by the way, in case you're not picking that up, a much more convenient way to document and then prove the FMLA violation. At the bottom, you see the little picture of Jake that we talked about at the beginning. That was the one where Jake's example put the easily discoverable opinions in an email to HR. And I would say our third nominee for case of the overshare of the year is the Holtree case, the second one at the top. In this one, the supervisor discloses the plaintiff's medical condition. We're going to need to, you may need to gasp during this one too. Supervisor discloses the medical condition at a staff meeting, and as a result, so that's bad enough, right? Then when the employee comes back, the employee's coworkers and subordinates start to make jokes and obscene gestures to the employee about his condition. And this was so bad that the court in this case said, while there's no express provision in the FMLA for a private right of action for disclosure of confidential information, the court denied the employer's motion to dismiss the case, saying that the employee must be granted some element of confidentiality of medical information under this case. So those are three good nominees. Let's talk, though, about how you should train your employees. Some of this is the same, but the first thing is keep the emotional response in check. They need to practice this. As we said here, consider role-playing. I know Jeff has actually done role-playing in some of his trainings. You've got to keep that emotional reaction in check. And the important thing is to understand when they get that information, especially from that employee who has been a terrible employee, who they doubt that this medical condition exists, or even that the family member that you're supposedly taking the leave for exists, so you're going to be angry, you're going to be gobsmacked, but what do? You need to tell them, you can tell your significant other about this, you can tell your therapist about this, I understand you're going to be angry, but you can't react. You have to, and that's why you need to practice. Consider a practiced response like below. The company and I fully support your ability to take leave when necessary. Please know how we can help. And you really got to do this, especially where, you probably know your managers and who may have more trouble with this or not. And then this too, for the other shades of this, where it's going in performance reviews, it's going in emails to HR, you got to make sure that they don't do this. Don't talk to others. Don't email. Don't put it in performance reviews. If you have something to say, you got to talk to HR about it on person or maybe over the phone, and preferably with your lawyer there, so that potentially you can get privilege. So again, millions of others of these cases, these overshare cases, but there's no time for that because we need to get to offender number 5.
The fifth type of manager that you're training in your session is the badgerer. Nope, not a badger, badgerer. You realize that no one outside the state of Wisconsin laughed at that joke.
Right.
Okay.
That's right.
All right. Just to be clear.
Yeah.
The manager who badgers the employee while they're out on FMLA leave. They want them to perform work while on leave. That's a problem. And so what I provide in a typical FMLA training session is typically 2 scenarios. I talk about Joan, a manager in the ethics department who needed time off, but yet her employer required her to work 20 to 40 hours a week while she was on FMLA leave. She returns to work and she resigns her employment. I mean, who wouldn't in this scenario?
Right.
And I asked the managers, is this an FMLA problem? And I get a lot of nods of the heads, of course, typically yes. And then I share this type of scenario with them. Well, what about this situation? What about Tammy, an assistant director taking leave to care for her husband after surgery? The employer called her at times during her leave. And according to Tammy, they called her between 3 and 10 times while she was out on an extended leave of absence to discuss work-related matters. One call talked about the hiring of an employee. They lasted anywhere from 5 to 30 minutes. And she later sued, claiming that her employer interfered with her FMLA leave. Is this an FMLA problem? So I pose that to the managers and share the results in these two cases. In Joan, clearly an FMLA problem. In Tammy's situation, not an FMLA problem. Sporadic phone calls of a general nature, typically to pass on information or that are administrative in nature, often are not going to be interference with FMLA. So when I'm training the badgerer here, what I remind them of is that what they cannot do. They cannot condition employment on completing work while they're gone. You can't require an employee to work while they're on FMLA leave. What can you do? You can contact an employee to request a password or access to a file, an update on where a particular matter was left off, to pass on institutional knowledge. But let's be clear with our managers. As a general rule, remind them in your training sessions that generally speaking, we want our employees to be left alone. Set up some mechanism. If your managers are going to be contacting employees while they're out on leave, create some kind of approval process, if you will, that they reach out to HR or to someone in upper-level management to get that permission first. If they need to communicate about work assignments, remind them to be concise. It can't be a significant amount of time, can't require travel to the workplace, except for some limited instances where they may have to attend a disciplinary hearing. Interestingly enough, several courts have said, yeah, you can require your employee to come into work on FMLA leave to attend a disciplinary hearing. Before doing that, though, make sure you talk to your attorney about requiring that attendance. If the employee agrees to do some work while on FMLA, particularly we're talking about white-collar employees, professional work environments, people who they're going to continue whether you allow them to do it or you deny them the opportunity, they're still going to work in some way, shape, or form while they're on leave. If that's the case, make sure it's voluntary. Make sure it's documented as to what the whole scope of the work is going to be, and make sure that you are compensating for any kind of time worked so that you avoid any wage and hour issues.
All right, and our final offender, the troublemaker. Now, the troublemaker is a little bit of a different shading of these other characters. In the troublemaker, your manager may say things and have those sort of offensive remarks, kind of like the overshare, but in these cases even worse, where the manager's participation in the employment decisions around that employee, particularly whether to terminate that employee, are seen as a part of the case and of the reason that the employer loses. So we take the Smothers case. Here we have Steve, an 18-year employee, a top-notch employee. Another reason to always make sure you spell check, because these things end up going into the cases. Taking an intermittent leave for a degenerative disc disease. He's denied a promotion. They say bad performance in his review for absenteeism. he has a dangerous safety incident, and he did. I mean, all parties agree this happened. He admits fault, something called an acid wash. 6 managers then conclude or conspire to fire him. They never asked him his side of the story, and there were other people that had problems with this acid wash process, and some of this probably sounds like a kind of a textbook FMLA case, but they were inconsistent on the treatment of other safety violations of this acid wash process of others. Smothers ends up winning this case. One from just a couple months ago, this Rosanna Jones versus Aaron's case. Here, she was a customer service representative at a retailer, and she has a back condition. She injures her back at work and was subsequently diagnosed with the back condition, and I think Harry Potter spell, quadratus lumborum myofascial pain, which she complained of radiating down her back. She takes FMLA leave, and the manager cuts her hours to 32 hours a week. So that may be a violation, but when she comes back, they put her back to the 40 hours. They then terminate her for inappropriate conduct and behavior a while later, months later, saying that she had a difficult relationship with her new direct manager, the one who cut her hours. And while the district court said, no, that doesn't count, that's not part of the termination process, when it went to the appeals court, the appellate court said, actually, it does. That's all part of the analysis, and so that manager's decision to cut her hours is all part, and that then that sort of souring of their relationship is all part and parcel of the termination decision. A couple others here. I just talked briefly about the Marshall case because that one's relevant. It talks about cat's paw liability, something we see somewhat often. It comes from Aesop's Fables, I believe. That's a situation that's referring to this kind of situation where a biased subordinate who doesn't necessarily have decision-making power uses the formal decision maker, or whose thoughts about the case are then sort of certified, so to speak, by the formal decision maker to trigger a discriminatory employment action. And that one, the plaintiff, the middle one, plaintiff Marshall said that she was asked about her opinion during a celebration lunch for her work and celebrating the work that she'd done. And she said in the case, I knew that the manager wasn't asking me that he wanted my opinion. He wanted to single me out and put me in a corner in front of my coworkers in the middle of a restaurant. So that action then again bled into and was influential in the employment decision. So final sort of tips about the troublemaker. First, again, train them not to say stupid stuff. Obviously, that's where this shares the sort of similarity to the oversharer. But in addition to that, HR people, anytime there's a leave involved and you're looking at a file, consider that a red flag. Look that case over twice, interview that manager, because you're going to have to do this stuff, or your lawyer is going to have to, if this case goes to litigation anyway. Take another few minutes, another hour even, to round that out and make sure you understand what happened. If the manager is documenting what happened, make sure that you review it before the decisions are made. It may reveal or evidence bullying, like it says, bad decisions, or some other animus toward that employee. All right.
Quick recap. Again, your training session should include 6 different topics, focusing on the space case, what constitutes an FMLA request, and what does your manager do with it. The lazy bones, don't sit on the information that you have when you know that it's triggering FMLA or ADA. What are their responsibilities in providing that information to the organization or company? Head stuck in the book. Be our eyes and ears to flesh out any kind of FMLA misuse so that you can take appropriate action. The overshare, control yourself, control what you're saying as a manager. Treat every instance of leave on its own in an objective manner. The badgerer, don't require employees to work while they're on FMLA. And finally, the troublemaker, keep them out of decision-making if at all possible, and add extra layers of attention if they are involved, an independent process for termination if they are somehow involved in the process. Before we move on to Q&A, just a quick self-serving note. I offer a number of services. This is Jeff. I offer a number of services in the FMLA and ADA areas. My CALM service is compliance and accommodations and leave management. It's a flat fee retainer that I offer my clients for Q&A issues that you're dealing with in the FMLA, ADA, state law, and it's on a retainer basis, a small retainer on a monthly basis. We also offer Leave Law Insights, which keeps you up to date on any changes in leave law at the state or local level. And then finally, please sign up for my blog, my FMLA blog, if you are not already a subscriber. It's fmlainsights.com. You'll see in the lower right-hand corner the circled area there. You can enter your email address, and you'll receive a confirmation that you have to click into to receive our updates on the blog. I blog several times a month, and it's meant to be a handy resource to employers in helping you administer FMLA. I don't spam you. I don't share your emails with anyone else. So rest assured that all you'll receive from me are a couple of infrequent emails from time to time with my blog posts as I post them. So in closing, I mean, what's an FMLA webinar without a little song, right, man?
Yes.
So backed by popular demand, but with in honor of the Bare Naked Ladies, we sing again this year. This year we poke a little fun at managers with the tune "Oh Rest Ye Bumbling Managers," sung to the song "God Rest Ye Merry Gentlemen," of course by the Bare Naked Ladies. And it goes something like this. I hired a volatile manager. His name was Ross. He always was on a power trip. People called him the boss. He tends to fire those with the gout or chronic IBS. Oh, tidings of FMLA, FMLA. Oh, tidings of FMLA. Bum ba ba da bum bum ba da ba da ba dum bum ba ba da bum bum. Ross told his secretary it's a bad time for medical leave. Then he gave her a parting gift, a book called No More Hysterectomy. I'm worried what next slur he'll use at our 3 p.m. meeting. Oh, tidings of FMLA, FMLA. Oh, tidings of FMLA. Oh, this law is a wonder. This law is a chore. It makes me scared to hire employees anymore. What if I don't train or fire Ross? Come tomorrow, I'll find the DOL at my front door. Happy holidays, everyone.
Weird.
Having to sit through that rendition, of course, earns you proper credit under whether it's HR or CLE. Here are your numbers. While you're jotting those down, for those of you that are seeking CLE credit, continuing legal education credit. We are an approved provider in Illinois, so if Illinois, you'll receive your certificate, and you can, of course, apply that to your CLE. If you're outside of the state of Illinois, you know that you kind of have your own quirky rules in getting that CLE approved. So we provide you the certificate, and, of course, it's then up to you to make sure that that is approved by your own state bar. Let's move on to Q&A. We'll leave our contact slide up to reach us through email, LinkedIn, Twitter. We provide pretty much everything except our mother's cell phone number, don't we, Matt? So with that, we got a couple of minutes for questions. Why don't you take one that's come in, Matt?
Yeah, we've had a lot. I've tried to sketch down some notes. There was one from Michael who asked about the duty to investigate by that manager, sort of coming out of the space case. How do you, and lazy bones, where do you draw the line on that? Jeff may have a better answer than this, but my answer is have your managers use your best judgment. As we said before, role play this a little bit. When you look at what these courts are doing, they are really looking at the reality of the situation and what the employer, particularly the manager, knew or should have known. So to the extent you hear something that sounds like it might be a serious health condition, make sure that they're either investigating that, asking more questions like Jeff said, or tossing it over to the TPA. The other thing to mention on that is, particularly if you're here in the Seventh Circuit, there are a few cases that talk about the employer's responsibility to infer the condition based on what they've seen. The Byrne case, the Stevenson case, they're a little old. There's actually one this year that went the other way. But it talks about if you see, the words they use are a stark behavioral change in that employee. A janitor who's worked for you 30 years, you know this guy, you see him every day, and all of a sudden he's acting very different, much more strangely, that may be a trigger. So you gotta be on notice. You don't want to sort of, there are to some degree privacy concerns, but as Jeff mentioned, HIPAA is not an issue. California may have different rules on this particularly, but you're going to want to understand how to get that information and get that employee to the right place to understand whether or not they need leave.
A couple of questions have come in about how do you explain to your managers the definition of a serious health condition. So specifically, one question came in that asks, our attorney has always explained to us that it's just that just 3 days is not FMLA, but 4 is FMLA. Do you agree?
Right.
Well, I think they need to find a new attorney. So it's just my off-the-cut tough thought. This is a trap. This concept of FMLA has to be at least 4 days or more than 3 days. In all instances, it's a trap, and you miss what is often going to be chronic serious health conditions, potential pregnancy absences. Keep in mind the FMLA applies, and most of us know this, in some situations when it's an absence of more than 3 consecutive days. But there are plenty of instances under FMLA where the employee is dealing with a migraine headache or a bad back and may need to come in an hour late to work, may need a day off of work or a couple of days off work. So that's a trap, and make sure that you're training your managers that FMLA is much larger than that. Same concept, a similar question that came in. We use 5 consecutive days to trigger the FMLA, and what is there an issue with this? Yes, there is, because you're missing out on those absences under 5 days that very well could be covered by FMLA. Now, you may have kind of an informal policy that says, if an employee is gone for the week, we're going to ask some more questions or we're going to dive further into the reason for that absence. But having that as a rule that always applies is going to be a problem for you. Another question?
Yeah, I saw one that was about what if the employee never completes their certification. So we talked about a lot of situations where the employer bungled it. I'm going to mention it for the 800th time, or left it in their car. What if the real issue is the employee is not turning the paperwork in? We get this question a lot. Can you count that as FMLA? And my answer to that is yes, absolutely, as long as it actually is a serious health condition and based on the information as you have it. So if you look at the regulations and the responsibility or the information about the employer's ability to ask for medical certification. It's permissive. It says the employer may ask for a medical certification. That's relevant because it's suggesting that the employer can designate a leave as FMLA even if they don't have that certification. I wouldn't recommend that as a general practice, but we have had situations where an employee won't fill it out, or even particular organizations where culturally they're not doing that, and the question becomes, can you designate that as FMLA? The risk there, I think, is going to be if they then come back later and say, no, it wasn't FMLA, how sound is your information that it was a serious health condition? And in addition to that, were you potentially being opportunistic to drain their balance? But otherwise, if you don't do that, you could have a situation where the employee can just take leave in perpetuity. Now, the last thing I'll say on that is it's the employer's option. So if an employee decides not to return the certification, that is the employee's responsibility. And to the extent that you want to then not designate that time as FMLA, which means unless there are other laws that may apply, they're at will. You can take action, and the FMLA does not then provide job protection for that employee.
I'll finish with one question. Before I do that, I do want to remind you to fill out the survey. It's going to pop up at the end of the webinar here. Please click into that link. We really need these surveys in particular for those seeking HR or CLE credit, so that we know that you attended, and then we know in CLE that we can actually send you the certificate that's required, the CLE certificate that's required by the state bar. So please fill out the survey after we're done here. We have run out of time for questions, but we do have one last question from a jokester, David in Arizona. Will listening to your song qualify as a mental health claim under FMLA?
For sure. Yes.
Well, I was thinking no.
Oh, right. No, it was beautiful.
Yeah, clearly they have a good taste in music.
Yeah, that's right.
That's it. That's it from us. Thanks a ton for attending. Please fill out the survey. Please reach out to us through social media or email if you have follow-up questions or want to chat about anything in particular. It's always an honor and a pleasure to be with you on these webinars. We hope that it's been of value to you. Please let us know what we did well and what we didn't do well. This feedback is always good to us. But thanks again, and happy holidays.
Happy holidays.